Welcome to Politics Nation. I'm live tonight from Buffalo, New York, and we start with breaking news. An Ohio judge has found probable cause that a Cleveland police officer should be charged with murder in the shooting death of 12-year-old Tamir Rice. This opinion is just an advisory statement. The decision to actually charge Officer Timothy Loman is still up to the grand jury. But the judge's opinion had some powerful words about what happened in that park when Tamir was shot while playing with an airsoft gun 201 days ago. The judge says, quote, "The video in question in this case is notorious and hard to watch. After viewing it several times, this court is still thunderstruck by how quickly this event turned deadly." He added, quote, "The video does not display the toy gun in Tamir's hands. There appears to be little, if any, time reflected on the video for Rice to react or respond to any verbal or audible commands." And, quote, "Literally, the entire encounter is over in an instant." The judge also said that probable cause exists to charge the other officer in the case with negligent homicide and dereliction of duty. This opinion today comes in response to a motion filed by a group of activists and clergy members. On Tuesday, they used an obscure Ohio law to ask the judge to review the matter directly. Tonight, the case still rests in the hands of prosecutor Timothy McGentry. He'll present the case to the grand jury, which will decide whether to charge the officers. But today's opinion could certainly affect how the public views that process. Joining me now from Cleveland is the Reverend Colvin. He's one of the clergy members who filed the court papers and outstanding leader in that community. They filed the papers asking the judge to review the case. We're also joined by Ari Melba, MSNBC's chief legal correspondent and co-host of The Cycle on MSNBC. Thank you both for being here.
Good evening.
Thanks for having me.
Reverend Colvin, what's your reaction to this announcement, first of all?
Well, obviously, Rev, having been a part of those who, what we call them the Cleveland Eight, those 8 individuals who filed the citizens affidavit, we are pleased to see that Judge Adrian saw what millions of other people saw around the world, and that is that a 12-year-old boy did not have a chance in any way, shape, or form to demonstrate any aggressive behavior, and in less than 2 seconds, his life was taken. And so for us, we know that this is only a part of the judicial process and that the wheel of justice slowly grind, but we know that this was an important step toward demonstrating and letting this process know and the world know that there is a judge and there are people who know that lives matter and this young boy's lives matter.
Now, the strategy behind this, you and the Cleveland Eight went and took an obscure law, filed this with a judge, though he did not and could not directly charge, but he released what struck me as a very powerful statement, saying that there was no toy gun in Tamir's hand, saying that it happened in an instant, saying there was no time for Tamir to react. I mean, and saying this while the world is looking at Cleveland, while LeBron and them are doing the championship games. I mean, this is a very serious impact on the public, if not on the actual charging of the officers.
Absolutely. We're all in with the Cavs, but more importantly, we're all in for justice. You know, it's interesting that people have talked about how this is a 60-year-old law, but the oldest law in the books is thou shalt not kill and thou shalt not shed innocent blood. And so for us invoking the Ohio Revised Code, which is really, it is a part of the same subsection in which is also given the right to officers to file charges when they are in doing their duties. It is a part of that same code and that same provision. And we simply exercise that. And for us, as we studied and researched ways in which we could begin to exercise citizens' power, we realized that there was a tool already on the books in which we could use the tools of democracy in order to move this. And it's for us really, really important as we become a part of this larger movement for law enforcement reform around our country, because we've seen responses that have been in many ways destructive and unproductive. But in the tradition of Thurgood Marshall and the NAACP and the Legal Defense Fund and that grand tradition, we have now used the law to advance the cause of equality and the cause of democracy in this country.
Ari, what impact on the legal side does this have on the overall investigation into whether charges will be filed in this case by this prosecutor and the grand jury?
Well, I think this kind of order has a significant real-world impact because the video that we're watching up on the screen, the video that so many people have seen and debated, exists out in the real world. This is an independent judge issuing his own independent conclusions about what the video means and whether, under the probable cause standard that was at play here, that lower standard, whether there is a justification for charges. So that's simply significant because that's new today. That wasn't the case yesterday. So 6 months into an investigation, this really is the first statement from the legal process. Now, having said that, as you mentioned in your setup to this news, Rev, it is certainly true that there is no automatic legal trigger here, and the judge, in careful legal language, emphasizes that in the order, saying that while it is possible that a prosecutor through the grand jury system can base further charges partly on what was found here because it's legally significant, they do not have to under the rules, under the state laws of Ohio. While this is a mechanism to have this advisory opinion and review, it's up to the sole discretion of the prosecutors how to handle the case. The only other point I'll make, which is somewhat obvious but certainly true tonight, is that these kinds of cases aren't processed in a vacuum to begin with. There is tremendous pressure on DAs who work with the police day in, day out to process every other case to be very careful when they're dealing with allegations of police misconduct. So for those who are concerned that there is a potential conflict there, which doesn't mean, by the way, there's anything wrong with what the police or the prosecutors are doing, but rather an inherent conflict in working so closely with certain people and then turning around and trying to investigate them. For those concerned about that kind of thing, this is an independent adjudication of the issue that is countervailing pressure, that goes pressed against that and says, well, hey, look what a judge already found. There's a problem here. There's a potential crime here. And so ultimately that should have some impact, although it doesn't automatically do anything.
Well, I'm certainly one that has raised that possibility of a conflict all across the country. In fact, I'm in Buffalo speaking at a judges conference as to that now. We just received a statement from Prosecutor Timothy McGinty, and this is what he says, quote, "This case, as with all other fatal use of deadly force cases involving law enforcement officers, will go to the grand jury. That has been the policy of this office since I was elected. Ultimately, the grand jury decides whether police officers are charged or not charged." Ari, what do you read from that? And what concerns me, and as people know, I've been out to Cleveland, spoke at the Justice Revival, Rev.Colvin. So I'm very concerned about this case, as many Americans are, that it come to a just conclusion. But the question remains, this is the same prosecutor that took over almost 2 years to prosecute in the case that we just saw an acquittal. He took over almost 2 years to even bring charges there, where 140 shots were shot at 2 unarmed people in a car, Ari. So could he try to wait this out and people forget what this judge said?
Well, I don't want to prejudge his process here with the grand jury, and we don't know, of course, what's happening within that process as they go through it. It's generally fairly secret under our rules. I will say that it seems potentially problematic in the statement you just read for him to put so much of the onus or the burden on the grand jury itself as if that is somehow something the jurors are doing. I think any lawyer will tell you, whether they're prosecutorial or defense-minded, that everyone knows in the American system the prosecutor has great weight when they present to the grand jury. And so one of the concerns is that on every other normal day and case, the prosecutors come in and push hard to get indictments, and then suddenly, in some cases of alleged police misconduct, suddenly it's a different mode, and they're saying, well, we'll just leave it up to the jurors. That's a pattern we've seen. Again, not to prejudge this particular case, too early to know, but the wording there does raise that kind of concern.
But doesn't the fact, Rev.Colvin, that this judge came out after you filed this Tuesday and in less than a week he came to a conclusion, how can then the prosecutor not act in a reasonable point of time to bring this to a grand jury and proceed? Certainly he's under pressure to deal with what a judge, an independent judge, had to say in a very short period of time, saying there's nothing there. There's no gun in his hand. There's no audible or verbal response that he could have given that or that he heard that he could have responded to.
Absolutely. Now we have had a judge look at the video. We've had the county sheriff to conduct investigation, and now even the county prosecutor said he's going to conduct his own investigation. Well, the world is now watching, and it's so interesting from that statement that you read. 99.9% of people who go through the grand jury process don't get the luxury of going into the grand jury process without there at least being a charge. What the prosecutor is saying, what he's not only just talking about an indictment, that he potentially would have these officers and have the evidence presented against these officers or regarding these officers without even a charge. And that is not what we see in our criminal justice system every day. Rev, you work on these issues. I work on these issues on a local and a state level. And 99% of the people who go through the grand jury process, when they have already been arrested, they go into the grand jury process already having been charged. And then it is upon the prosecutor to lay out the case to substantiate any number of those charges. What you're hearing from Mr. McGinty is that potentially without even having them charged, they will be able to go into the grand jury, maybe offer self-serving testimony, out of which then he could determine whether there's both a charge and an indictment. And I'd like to hear from the attorney also being interviewed, because I'm not sure if that's what 99% of the people who go through the criminal justice system experience. It's almost as if police are protected class here.
I don't know if it's 99%, but as we wind up, I know that in the last several weeks, we saw in North Charleston, South Carolina, in the Deep South, an officer was arrested and charged, and he was just indicted by the grand jury this week. We saw in Baltimore a charge, just an indictment this week. So clearly what you're saying has been a pattern we've seen recently in different parts of the country, including the Deep South. So I think the onus is on this prosecutor. I'm reminded that the chief judge in New York, former chief judge Saul Watler, Ari, used to say, if a prosecutor wants to, he can indict a ham sandwich. The reverse is also true. He cannot indict a ham sandwich if he doesn't want to. The world will be watching to see what this prosecutor does, particularly now the judge has said this, an independent judge looking at the evidence. Ari Melba and Rev. Colvin, thank you both for your time tonight.
Thank you, Rev.